The first case on the call of the docket is agenda number 14, number 126606, PNC Bank National Association et al. Versus Jerzy Kusmierz, Mr. Giovanni Antonio Raimundi.
Good morning. May it please the court. Giovanni Raimondi, on behalf of appellants Jerry and Helena Kusmierz. This matter comes before this court on two issues stemming from the Kusmierz's Section 2-1401 petition, which challenges as void judgments entered against them in a foreclosure case that not only divested the Kusmierz's of their property, but levied a personal judgment against them in excess of $50,000. As alleged in the Section 2-1401 petition, the judgment entered against the Kusmierz's is void because the record reveals service on them by Metro Detective Agency before being appointed to do so was complete. This court's recent opinion in Municipal Trust and Savings Bank versus Moriarty succinctly stated that for a private detective to serve process on a defendant in Cook County, he or she must be specially appointed by the court. That was not the case in this case. Though the invalid service of process was raised, the circuit court denied my client's due process challenge. The appellate court affirmed the denial, which brings my client's due process challenge before this court. The two issues before this court for review are whether purchasers of property are considered bona fide when the foreclosure record shows that purported service had been accomplished by a special process server prior to the special process server's appointment by the court. And second, whether the equitable doctrine of laches can be applied in a Section 2-1401 petition that challenges the judgment as void because of a jurisdictional challenge. Turning to the first issue, respondents do not qualify as bona fide purchasers pursuant to Section 2-1401E, whereas here, the jurisdictional defect is apparent on the face of the record. Specifically, the record reveals that on March 30th, 2011, there were 4 summons issued, 2 summons for Jerry, 2 summons for Helena. The very next day, the process server attempted service at the property address but was unsuccessful. That following day, the plaintiff completed a form, motion, and affidavit seeking the appointment of Metro Detective Agency to serve all summons and all writs. That same day, before the court ruled on the motion, Metro Detective Agency served process. 3 days later, on April 4th, 2011, the court appointed Metro Detective Agency to serve process. The First District's opinion in Johnson, a case relied upon in this court's recent ruling in Moriarty, held that purchasers of a property previously foreclosed were not bona fide purchasers, where the record showed that a special process server served process before being appointed to do so. In so holding, the court reasoned that serving process before the court appointment was sufficient to notify a purchaser of a potential jurisdictional defect. The key in Johnson was that the record notified the purchaser of a potential jurisdictional defect. The facts of this case are no different than in Johnson, and they dictate no different result.
Counsel, how do you accord Johnson with Justy and some of the other cases that talk about where the county is not stated on the summons and the parties are allowed to rely on the 2202 affidavit?
In Justy, there was no motion, affidavit, or order appointing the special process server after that. It was merely just the affidavit, the return of service affidavit that was in the record, nothing else. I do believe those cases were incorrect in granting 1401E protection to the purchaser. However, that issue isn't before this court. This issue is a little bit different because we have a motion and an affidavit and an order seeking the appointment of the process server. It's more akin to the Johnson case in the First District than it is to the Justy case or the Robinson case in the Second District.
Counsel, are you suggesting that a potential purchaser must exercise extended due diligence. In other words, here on the face of the document, it said that there was service in Palatine. Are you suggesting that a potential buyer must go beyond that and do search whether or not there was appointment of process server, what county Palatine was in? What's required of a potential buyer?
To act reasonable. And under 1401E and the case law, under Thill, under unknown heirs and legatees, and under Concord Heir versus Millars, that's what the court said. It's enough to raise a potential jurisdictional issue on the face of the record. And here, what we have a timeline of there was an attempted service. The very next day, the plaintiff and bank knew they needed appointment. They completed the motion, they completed the affidavit, but didn't wait until the court granted that motion.
Are we supposed to be looking, though, at my question's about the purchaser. What does the purchaser have to do? Does the purchaser have to investigate the process server before they continue on with the purchase?
Here, if they just reviewed the record, and inside of 15 pages of the record, it would have revealed the timeline and the appointment, and that was enough for a reasonably prudent purchaser to inquire further. And that's what unknown heirs and legatees held, and that's what Concord Heir versus Millars held.
Mr. Giovanni, why did it take 7 years before the 21401 petition was filed?
That I can't answer, Justice. Unfortunately, as soon as I was retained by the Kusmierzes, I acted diligently and filed the 1401 petition. But as Illinois, this court has held that a jurisdictional challenge to a void order is not subject to the normal time constraints of a normal 1401 petition that alleges meritorious defense and due diligence and has to be brought within 2 years. Under Sarkisian and under Mitchell, it can be brought in perpetuity.
Is that a chilling effect then to any purchaser if they have, as Justice Tice says, some extra due diligence to look at the process server and bring it up themselves?
The argument was raised in Thill that the ruling in Thill would have a chilling effect on home sales that had resulted from a prior foreclosure. And in Thill, this court ruled that one's due process rights are paramount to alienability of title. And it was, if there are issues that are apparent on the face of the record, that's why the legislature enacted 1401E, because they realized if it's not apparent on the face of the record, then title can't be affected. But if it is apparent on the face of the record, and what the case law holds to be apparent on the face of the record, which is enough to raise the issue of a potential jurisdictional defect. It's not needed to know absolute. Well, we need to know the county. Is it in Cook County? We need to know the population of Cook County. That's not what the case law has rendered. And that's what we feel has struck in the balance between alienability of title and one's due process rights.
If we agree with you, what happens to the improvements in the property?
I can't answer that, Your Honor. I believe the Section 1401 petition is really concerned with whether the judgment is void or not. What happens in the underlying case, that's for the circuit court, I would submit to rule on it.
Does that go to whether the equitable doctrine of laches should be applied?
So,
because of the 7 years and the improvement in the property?
The improvement, it could be an offset, and I don't know. However, the issue here is not only was my client's property taken without due process, but there was a personal judgment levied against my clients. And I believe that the issue of laches has been dealt with in a way that vitiates by this court. Laches cannot be used to interpose a defense to a due process challenge. Otherwise, we concern ourselves with avoidable judgment and not so much a void judgment. We equate jurisdiction to now only notice and not service of process. It distills down the due process rights afforded to every citizen in the state of Illinois.
To get back to Justice Tice's question, the Chief Justice's question, the answer to Justice Tice's question is yes, right?
I can't recall.
Well, her question was whether a bona fide purchaser or someone that's buying property that's been taken in foreclosure has an independent obligation to go search the record.
That is what the law holds. That the law holds in 1401E. That's what the legislature has said. That if the jurisdictional defect is apparent on the face of the record, a purchaser, when they draw a title and they see that this property was subject to a foreclosure, it's incumbent upon them to look at the foreclosure file and see, was judgment rendered properly and or not? And if they believe it's not and they resolve those issues through due diligence, then they have satisfied the bona fide purchaser argument. But if they don't look at the record and they don't, if the record reveals that there's a potential jurisdictional defect and they don't exercise due diligence in resolving those issues, then they are not a bona fide purchaser. And that's what the legislature has determined how to, again, protect one's due process rights and the alienability of title. And I would submit that.
Mr. Raimondi, are you saying that your clients had no actual notice? There were.
I'm not saying that, Justice.
Okay. And then what? So they actually knew that there was a case pending, and didn't they default?
They were defaulted in the case.
So even with some notice, they didn't do anything for more than 7 years?
I believe it was 6 years,
6 years.
Justice.
You know, in this case, you could allegedly argue that you've got two innocent parties here, but you've got one party that waited 6 years and they knew something happened, right? Something happened to the property. They're aware of that, your client.
Yes, yes, Justice.
And yet they waited this length of time, and in the meantime, somebody else, innocent party, with both parties being innocent, another innocent party purchased the property, a bona fide purchaser.
We don't believe they are a bona fide purchaser. And an innocent party is not considered a bona fide purchaser under the case law. So we believe with the record here, they should have perceived a jurisdictional issue and attempted to resolve those issues. There was no evidence provided by the 1401 respondents that they looked at the record, that they saw issues, that they tried to resolve these issues.
Well, could your clients have looked at the record and resolved these issues without waiting 6 years to do that?
Arguably, yes, Justice. But again, we have the issue of there's a personal judgment against my clients and their property was taken. So with that, then we're saying that due process is no longer afforded a protection under the Constitution of the state of Illinois. And we're just saying, well, notice is enough. And I don't believe that to be the case under the Constitution and under the case law.
Counsel, is it your position that a party has no responsibilities when they receive notice if it's not pursuant to the statute?
Justice, I wouldn't say that they don't have duties or should have acted differently. However, my focus when I'm looking at service, it's not on the defendant. It is on the plaintiff seeking the court's assistance in compelling a sale of a property and the levying of a judgment.
One of the most important parts of due process is notice, and they did receive notice on April the 1st. Is that correct? 2011.
Arguably, yes, Justice. But the other part of service is for the court to acquire jurisdiction over the party, to compel them and have power over them to do something. And here, there was no jurisdiction. There's been no argument that there was jurisdiction. Now, in the briefs before this court, there was an argument about the third district decision in Moriarty. However, since that time, this panel has rendered a ruling on Moriarty and said that the service was improper. So with service being improper, how do we now protect my client's due process rights that were violated?
So in your argument, Moriarty answers the question totally.
Of service, yes, Justice.
The appellate court conducted a 1401E analysis as to the purchasers and a laches analysis as to the bank. If laches applies, doesn't it apply to everybody?
If latches, it's hard for me in my position to say that latches could apply to the bank, because at that point there would be an argument of unclean hands. Because but for PNC Bank's representation to the court that they had properly served my clients and obtained a judgment of foreclosure and a personal judgment and allowed the property to go to sale, I believe they had unclean hands.
Well, let's forget about the bank then. Let's say they had unclean hands. Does latches apply to the purchasers?
It's my opinion that no, latches would not apply to the purchasers. The legislature has enacted 1401E and recently amended 1401E to include everyone in the chain of title, including the current lender and property owner. And in that, the legislature in 2018 could have amended 1401E to specifically include latches elements of due diligence and meritorious defense. And in lieu of doing that, they said that, no, we understand the balancing between due process rights and alienability of title, and we're going to modify 1401E to provide that, but yet still allowing a greater protection for due process.
And your clients, of course, under your argument, could have waited 100 years, wouldn't that?
Under Mitchell, there is no time limit to bring a challenge to avoid judgment, Justice. The appellate court, getting back to 1401E, in Bank of New York versus unknown heirs and legatees, addressed and actually rejected respondents' argument that bona fide purchaser protections under 1401E are more circumscribed than bona fide purchaser protections under common law, which was argued by respondents in their response briefs. Therein, the court held that a purchaser having actual or constructive knowledge or notice of facts contained within the record that would put a prudent man on inquiry is chargeable with knowledge of facts he might have discovered by exercising due diligent inquiry. Here again, the record reveals that the plaintiff completed a motion and an affidavit on April 1st, seeking to appoint Metro Detective Agency to serve all process in the case. Metro Detective Agency serves process on April 1st. However, the court did not appoint Metro Detective until April 4th, days later. Similarly, in Concordia versus Millars, the court held that purchasers were not bona fide purchasers under 1401E, noting that the purchaser did not need absolute proof of the jurisdictional defect, like a finding of lack of jurisdiction, noting that simply reviewing the documents would have revealed a potential jurisdictional defect worthy of further inquiry. Millars rejects the notion that the county and the population need to be identified to be apparent on the face of the record. Moreover, it must be noted that 1401E makes clear that should the purchasers be considered bona fide purchasers, it does not result in a dismissal of the petition. It merely means that title cannot be affected. Turning to the issue of latches, while the respondents cite two cases in support of the argument of the application of latches, there is not a single case on point. And in fact, the Supreme Court case on James versus France ruled that service of process was proper, and it involved mineral rights, none of which is applicable here. Service of process was improper. There are no mineral rights, and there are no adoption rights of minors, the other instance in which latches can apply. Also, in applying latches to PNC offered no evidence in support of its prejudice. Thank you very much.
Thank you, Mr. Ramundi. Mr. Levin?
May it please the court, Frederick Levin for PNC Bank. Appellates are right that a void judgment may be attacked at any time. That is the rule, and that is the rule that protects the due process rights that Mr. Ramundi spoke about. However, there is no conflict between that rule and the long-established rule that laches may be raised as an affirmative defense to respond to a 214-01 petition asserting a void judgment. This court and numerous appellate courts of this state have repeatedly recognized that in the appropriate case, laches can apply without sacrificing the rule that void judgments can be attacked at any time. Now, Mr. Ramundi addressed the issue of unclean hands as to my client, and the law in this state has been clear that unclean hands applies only when there's evidence of bad faith or fraud. Mr. Ramundi and appellants have not argued that there was bad faith or fraud here, and the record simply doesn't reflect it. So the unclean hands defense is a red herring. Justice Neville raised the question of the defendant's responsibility, the Kusmierz responsibility, once they got notice, and it's clear and it's admitted, you heard it admitted again, that they did receive notice. And it's also been admitted that they waited close to 6 years for taking any action. The fact that they were not served properly, though perhaps not attaching the jurisdiction of the court, and maybe not requiring a duty for them to answer the complaint, does not mean that there are not other duties under the law. The law of equity says you can't stand by when someone else is improving your property and you know it and remain silent. The record here is they did so for not 1 year, not 2, not 3, not 4, not 5, but over 6. In James versus Franz, this court held that the judgment of laches is a familiar defense when the validity of an earlier judgment is attacked. James specifically approved similar holdings of this court dating back to the 1930s and disapproved of a few outliers that were to the contrary. James was decided in 1961. This court has not issued a contrary ruling in the 60 years that have passed since it decided James. During those 60 years, the appellate court, relying on James, has published 8 decisions of the First and Second District appellate courts, which collectively represent the views without dissent of 18 justices of the appellate court, recognizing that laches is an appropriate defense. This case demonstrates, for the reasons the court has already alluded to, why the invitation of appellants to overrule James and all of the subsequent cases should be rejected. As we've already discussed, the appellants received notice and waited for over 6 years to take action. During that time, the property was sold not once, but twice, and substantial sums of money were invested by the subsequent purchasers, and PNC carried the property for 14 months and bore all the risk of owning the property, including payment of taxes, during that 14-month period. So, after 6 years of inaction, during which time appellants received notice of the foreclosure sale, notice of entry of judgment, notice of the hearing for confirmation of the sale. Something happened that made them want to assert their rights. Their prayer for relief here offers some insight as to what happened. In the prayer for relief, they demand the property, including the house that was built with subsequent purchaser's money, or they demand the equivalent of the property plus the house in money damages, as if they built the house themselves. They demand that the subsequent purchasers be evicted from their home, and on top of that, they demand payment for use and occupancy for each of the roughly, wait for this, 2,388 days during which they did nothing. They say they're entitled to be paid for each one of those thousands of days. Appellants are attempting to turn a mistaken service of process into a windfall. The scheme works only if the court agrees with appellants that laches cannot be raised as a defense. The appellate court saw this case exactly for what it is and properly held that laches is a defense. Excuse me for 1 second. To justify eliminating laches, appellants point out that due diligence is not an element of proof for them under Section 214.01. PNC agrees that due diligence is not an element of appellant's prima facie case for relief. But it does not follow that appellant's unreasonable delay must be excluded from the proceeding altogether. To be sure, proof of due diligence and unreasonable delay share common factual elements, but it is PNC that carries the burden of pleading and proof for a laches defense, and the defense requires proof of two elements: unreasonable delay and resulting prejudice. Therefore, allowing the defense of laches in no way increases appellant's burden under Section 214.01.
Counsel, may I stop you for a moment before your
Yes.
last transcript and ask you some questions about the bona fide purchasers?
Sure.
Here in this record, there was an affidavit that service was in person was had, that finishing with the statement, I am a registered employee of this detective agency, licensed, and have been authorized to serve process within the state of Illinois pursuant to the statute. Was there a requirement on the purchasers to investigate further?
In my mind, that setting that as a requirement, I would answer that in the negative. I think it is sufficient for the reasonable person looking at it to read that record and assume that service was proper. I don't believe that we should expect of the average purchaser of real estate to inquiry deeply into the court record and to compare dates from one document to the next. Turning back to my argument on laches, for reasons similar to the ones I just talked about, how there's no conflict between the fact that void judgment can be attacked at any time and recognition, continued recognition of a laches defense, for those very reasons, the court's holding in Warren County versus Waters that equitable considerations are inapplicable to petitions raising a purely legal challenge to a judgment, those Warren County versus Waters offers nothing against the recognition of laches. The holding must be understood in the context with the question that the court considered, which was the circumstances under which equitable considerations can apply to determine the sufficiency of a petitioner's prima facie case under 214.01. Since the focus in Warren County was solely the petitioner's prima facie case, the court necessarily did not address the related question of affirmative defenses. Indeed, the decision does not mention affirmative defenses and should not be read to have decided such a substantial point by silence. Reading Warren County in this way aligns it with James and the subsequent many published cases recognizing that laches is a defense when there's a allegation of a void judgment. It also, sorry, go ahead. Did you have a question, Your Honor?
Your time.
Oh, I would just quickly close by pointing out that the facts here demonstrate the prejudice to PNC is unable to recover the property. There's a statute of limitations issues, just as the appellate court found. And there is the issue of the fact that the plaintiff's conduct increased its damages by delay. And the court in Kusmierz and each of the 9 justices of the Second District Appellate Court examined facts just like that are present here, and all 9 of them have found these facts constitute prejudice for the foreclosing party like PNC and for the subsequent purchasers. Thank you, Your Honor.
Thank you, Mr. Lara.
Good morning. My name is James Larson, and I represent Applebee's Brian Heath, Melissa Ragland, as well as their home mortgage lender, Mortgage Electronic Registration Systems, as nominee for STC Capital Bank. Almost 8.5 years ago, Brian and Melissa purchased a vacant lot located at 1405 Wisconsin Avenue in Lombard from PNC Bank. The couple paid $24,000 for that land. Slightly more than a year and $335,000 later, the couple moved into their new 5-bedroom home that they constructed on the property. To this day, Brian and Melissa reside in that home, paying their mortgage and real estate taxes and making sure the property is properly maintained and insured. For the last 3 years, there's been considerable angst in my clients' lives as they worry about whether or not they might lose ownership of their home as a result of the appellant's efforts to unwind the foreclosure by which PNC acquired title. In their petition, the appellants don't claim that they didn't receive PNC's summons and complaint or that they weren't aware of the foreclosure. Rather, their challenge is predicated solely upon the failure of PNC to appoint a special process server before arranging for them to be served in Palatine, Illinois, which we now know is located in Cook County. At this point, we've heard considerable discussion regarding the applicability of laches as a defense to the appellant's Section 214.01 petition. I won't belabor the point by going over all of that again. I would like to point out, however, that it seems to me the appellants have taken facially inconsistent positions. On one hand, they argue that a petition filed under Section 214.01 raises purely a legal question whether service was proper, such that a laches defense has no application. On the other hand, they go on to distinguish a number of cases in which this court and other appellate courts in the state have found that relief from a void judgment can be properly denied by laches when there's an evidence of a lack of diligence in pursuing the claim and that a defendant demonstrates the prospect for prejudice if relief is afforded. One explanation for this confusion, in my estimation, is the appellants seem to have lost focus on the fact that a Section 214.01 petition represents the commencement of a new action, albeit one that is part or a continuation of the underlying case. That being the case, it is first incumbent upon the petitioners to set forth a viable claim in their petition. In response to a legally viable petition, a defendant can file a challenge to the legal sufficiency of the plaintiff's claim or the petitioner's claim under Section 2615 of the Code of Civil Procedure, allege an affirmative matter that defeats the petitioner's entitlement to relief under Section 2619, or, as here, a combination of the two under Section 2619.1. To the extent the parties are ultimately an issue, it's left for the court to decide the strictly legal issue as to the propriety of service. As is the case in other analogous proceedings, the fact a court is required to answer a legal question, like whether a defendant was properly served, does not render a laches defense non-viable. Having, I think, now demonstrated, and at least in my mind's eye, the applicability of the laches doctrine, I'd like to focus for a moment on the prejudice that Brian and Melissa and their mortgage lender will sustain if the relief they request is granted. First and foremost, Brian and Melissa stand to lose title to their family home, a residence that they paid over $360,000 to purchase and construct. At the same time, Mortgage Electronic Registration Systems stands to lose the mortgage lien interest it accepted as security for the loan. Finally, Brian and Melissa will be left in the unenviable position of being forced to pursue at least a $335,000 unjust enrichment claim against the appellants who were previously unable to service a $120,000 mortgage loan.
Counsel, you raised laches in your 619.1 motion, correct?
We did.
Do you have, what's your take on the appellate court discussing laches as it relates to the bank and then ignoring it as it relates to your parties and just discussing the bona fide purchaser issue?
Well, Judge, I think that by virtue of the fact that the argument appears in the record, that this court can affirm on any basis, and that in light of that fact, it's appropriate for the court to consider whether or not the trial court properly concluded that my clients will sustain prejudice and are entitled to the protections afforded by the doctrine. So, Judge, in that regard, Justice, in that regard, it clearly appears to me that Brian, Melissa, and Mortgage Electronic Registration Systems will be prejudiced if the appellants are afforded relief. At the same time, we should not forget that the appellants offered nothing in the trial court to refute these forms of economic prejudice, much less demonstrate that they were unaware that a home was being constructed on their lot and that someone else was paying their property taxes. Next, I'd like to spend, if I could, just a few moments discussing the applicability of the BFP protections that are provided by Section 214.01e. Under that provision, third parties who acquire title to real property that was the subject of a foreclosure are entitled to bona fide purchaser status when they weren't parties to the original litigation, where they acquired their title or other interest subsequent to the entry of the order confirming the foreclosure sale and prior to the filing of the 214.01 petition, and finally when the jurisdictional defect of which they complained was not apparent from the record. Here, the appellants do not dispute that Brian, Melissa, and their mortgage lender satisfied those first two criteria. Rather, it is the appellant's position that the jurisdictional defect of which they complain was apparent from the record. More specifically, the appellants argue that the foreclosure record disclosed that they were served in Cook County by an individual who was not previously appointed as a principal process server. The necessity of appointment, of course, arises under Section 2-202 of the Code of Civil Procedure, which provides that in counties with a population of more than 2 million people, service must be effectuated by the sheriff unless a court appoints a special process server. The first issue of the appellant's contention is that the record does not reflect the county in which they were served, much less its population. The appellants acknowledge as much by virtue of the fact that they asked the trial court to take judicial notice that Palatine is in Cook County. The trial court properly rejected that request, recognizing that judicial notice is an evidentiary rule as opposed to a basis for imputing notice to third parties of matters not otherwise set forth in the record proper. As their final attempt to demonstrate that there was a matter appearing of record demonstrating that service was improper, the appellants point to an order granting a form motion seeking appointment of a special process server that was entered 3 days after they were served with what we now know, and now what we now know was Cook County. That type of challenge, of course, was recognized in CTASS and U Federal Credit Union versus Johnson. in Johnston, the after-the-fact appointment order provided notice that there was an issue with service. In Johnston, however, there was a single defendant. Here, there were obviously multiple defendants that were being served. And if anything, by virtue of the fact that PNC sought appointment of a special process server, in my mind's eye, it demonstrates that they were conversant with the requirements of 2-202, and for whatever reason, whether or not they were concerned about being able to find a defendant, they thought it prudent to seek an appointment of a process server. Thank you for your consideration.
Thank you. Mr. Raimondi?
I wish to address PNC Counsel's argument about James versus France and all the cases that they rely on latches. Every single one of those cases is distinguishable. James versus France, there was proper service. In Pyle versus Farrell, there was proper service. In Coberlin, there was no void judgment. In Slane's Property versus Haslett, there was no personal jurisdictional issue. In Dublin, there was no due process issue. That's why latches was allowed. Also, latches was allowed in Pyle versus Farrell and James versus France because the original parties to a conveyance had long since passed, and the intent of the parties could not be ascertained. That is why latches was interposed. We are not seeking to overturn any of this court's rulings or the appellate court's rulings that follow the fact that once there's a void judgment, it can be attacked in perpetuity. What PNC and their other respondents are seeking to do is overturn Mitchell. They are seeking to overturn Sarkeesian. They are seeking to overturn all that progeny which says latches cannot be interposed when there is a void judgment. To allow latches to be interposed would essentially distill down one's due process rights. It would distill down service of process to mere notice. And mere notice, PNC is now saying mere notice was enough to not only take my client's property, but it was also enough to levy a personal judgment in excess of $50,000. That simply isn't in the Constitution. With regard to third-party respondents' argument that appellants have somehow lost their way regarding a purely legal challenge and a factual challenge, we have not. A purely legal challenge says that there is a void order. It's a Vincent-type petition, as per this court's ruling. There is no need to assert a meritorious defense or due diligence. They attempt to argue a distinction without a difference. That, okay, fine, a 1401 petitioner can argue that it's void and never have to allege, let alone prove, due diligence or meritorious defense. But that doesn't mean they can't allege lack of due diligence against the petitioner. That simply isn't the case. That is not what prior rulings from this court have held. To do so would make no difference between a 1401 petition that alleges a void judgment versus a 1401 petition that challenges a judgment rendered in 2 years with a meritorious defense and due diligence. It simply isn't the case. That's all.
Thank you, Counsel.
Thank you.
Case number 126602, PNC Bank versus Jerzy Kusmierz, known as agenda number 14, will taken under advisement today. Thank you, Mr. Raimondi, for your argument this morning, and Mr. Levin and Mr. James Larson.